All right, guys. Welcome to Read the Fine Print, Legal Landmines and Locum Tenens Contract. My name is Rob Mohr, and I just got off shift, and I'm going to get us started. So welcome to the March AAEM Locum Tenens section webinar. Today, we're discussing the contractual side of locums. We're going to take some deep dives, but also try to cover some broad ground regarding locums contracting. Alex, can we go to the next slide? With failures in the business models of Envision, NES, and APP, it's become all too clear that contingency planning in emergency medicine is not just a nice to have, but rather an essential part of starting a new job. In fact, as of the fourth quarter in 2024, some of the largest employers of emergency physicians, e.g. Envision, Team Health, Schumacher, Sound, and U.S. Acute Care Solutions, have either filed bankruptcy or have speculative credit ratings, the highest risk investment profile that a company can have. The business model of emergency medicine is unstable, to say the least, and physicians need to ensure that they aren't left holding the bag if the house of cards falls. Today, we're digging into the fine print of our contracts. This is the stuff that many locums doctors skim over. We see so many contracts that they all just start looking the same after a while. But today, we're fortunate to have Alex Nguyen, a healthcare contract attorney who works directly with physicians. And he's here to help us unpack how to protect ourselves when working as independent contractors. We're going to cover setting up your contract to protect yourself if a group goes bankrupt, making sure your malpractice coverage extends beyond your shifts, as well as some of the most common and costly contract pitfalls. So let's jump right in. Alex?
Great. Thank you, Rob. And thank you for the invitation. I came off a shift that's much shorter than his. And so I'm happy to be here. So let's get started. For a long time, I've been in awe of emergency physicians, right? Like I think of you guys as really the SWAT team of the healthcare system. You provide critical care in critical moments with superhuman dedication and like no sleep. And you are expected to be perfect in a healthcare system that's anything but perfect, as you know, right? So, and as Rob pointed out, so my job here is to ensure that while you're out there saving lives, your contracts are working for you, not against you. And so, you've dedicated your career to taking care of others. I want to make sure your contracts take care of you. So let's dive right in. Let's start with a simple but shocking fact. About 90% of people never fully read what they sign. Let me repeat that. 90% of people do not read fully what they sign. And that includes lawyers whose job it is to draft and review these contracts. And when it comes to locums contracts, that can be a really costly mistake. So in this presentation, I'll focus on three main areas here. Number one, I'll cover locums contracts and how to guard against financial instability from providers that are driven by private equity. And you saw this slide from Rob earlier. I'll cover common pitfalls on how to avoid them. And here it's not just about reading the contracts, but fully understanding the implication and the risk hiding in the legalese and the interplay between various contract provisions, right? So it's about eyes wide open. And third, I will equip you with negotiation strategy and tactics, right? Here, the most important strategy is just deciding to engage and negotiate, not just sign the dotted line. Like 80% is just showing up and deciding you're going to negotiate. And a reminder, this presentation is not intended to be legal advice. It's informational. Ethics rules require me to say this. After a long shift, hard hours, big loans, small stipends, tough interviews. Why can't I just sign the standard contract, right? That's what everybody says. We're just giving you the standard contract. And when I was on the other side sending out contracts, my tactic was often to print out the contract or turn the contract into a PDF file. I'll sign it and send it to the other party, hoping that they'll just look at it and say like, oh, I guess the contract's fully baked. Let me just sign it. And look, the answer here is you can just sign the contract, but you'd be making a big mistake, right? because calling something a standard contract when you get it, it's just an official sounding phrase designed to discourage edits or pushback. But the standard contract is absolutely negotiable, and you should at least try to do it. The reality is that contract was drafted by lawyers paid by the agency to tilt it, to maximize discretion and minimize risk, and to shift the risk to you. And it's nothing sinister or personal, it's just business. So you should try to even the playing field. And especially at locums, where you don't have the same protections as employees. So again, make sure you fight back. The contract determines your quality of life, and you don't want to be kind of left in a lurch when the provider goes under, as many physicians recently found out with APP, NES, and Envision. I spent a couple of minutes here looking at some headlines here that you see about various providers, right? Like the model here seems to be, here today and gone tomorrow, right? That's the model for emergency physician staffing firms in the world run by private equity. And the headlines here tell you a story that no physician ever wants to be a part of. Staffing firms shutting down overnight, leaving emergency physicians unpaid, unprotected, and scrambling for answers. And as Rob's slide showed you guys earlier today, right, in this presentation, these companies, even though they have big names and big dollar figures and wide coverage, they're not exactly shining examples from a financial strength point of view. And companies like Envision, NES, APP, they seem stable, but then they collapse without warning. There were red flags, and we'll cover them, but they collapsed without warning. And physicians who had worked long hours, cared for patients in critical moments, and relied on these firms for the paychecks were suddenly left out in the cold, right? No final payments, no malpractice coverage, and no recourse. And this isn't, I just want to emphasize here, from these headlines, it's not a rare occurrence. Locum's landscape here is filled with companies that can disappear just as quickly as they appear. And if your contract doesn't protect you, if you haven't planned for the worst case scenario, you could be the one holding the bag, right? So I'll spend some time here talking about things you can do in your contracts to protect yourself for when the music stops. All right, so to understand the systemic risk here for various staffing agencies and why they go under and how it affects your contract, I want to spend some time here kind of stepping back and just understanding the business model of some of these agencies, right? Increasingly, this is an increasing pattern because private equity entities apply the same playbook over and over in acquiring these companies and running them. So I'll dive into the case study here with Envision Healthcare. It's the largest physician staffing firm in the US, as you know, 70,000 HCPs and 540 facilities across 45 states. But in 2023, 2 years ago, it just collapsed right away, almost overnight. And how did that happen? And what does it mean for you as a locums physicians? So first, on the left-hand side, you see here in 2018, private equity giant KKR acquired Envision in what's called a leveraged buyout. So let me step back here. So KKR is Kohlberg, Kravitz, and Roberts. They're one of the biggest private equity companies. And they were the main player in the book called, or a movie called Barbarians at the Gate, if you remember that book or that movie about the takeover of Nabisco. And they were the guys who basically invented the LBO, which is the leveraged buyout. And what a leveraged buyout basically is a company, KKR will buy a health group, right? And they don't buy it with their own money. They buy it with debt by taking out massive amounts of loans to buy the debt. But they don't take on the loan. They put the loan into the company. So they put the $5.3 billion loan into Envision Healthcare. And so it lives on the balance sheet of Envision Healthcare, and it's collateralized by the assets of Envision Healthcare. So KKR has no skin in the game, or very little skin in the game. So you can imagine the incentive they have to do things by the book or do things right or have patients and doctors in mind when they do this. And the idea here is you load up the entity with a massive amount of debt, and then you repay that debt with cash flow from the business, right? You service the debt with cash flow from the business. And so they get they juice the cash flow by basically cutting costs, making doctors work longer hours, cutting corners wherever they can, with the idea that eventually, after a couple of years, they'll be able to flip the business, resell it, IPO it at a profit. And so that basically is the playbook for a leveraged buyout. In this instance here in 2019, they loaded the Envision with $5.3 billion of debt, and they touted sort of high-tech practices, et cetera. We're going to innovate. We're going to take Envision Health from a clipboard and paper world into a computerized world and modernize things. But essentially, it's all basically a gimmick, because as you see into 2020, a large part of the cash flow came from use of out-of-network doctors for bills. So the way that works is the secret sauce here for the company was for patients to show up at a hospital that's in network, right? They would get serviced by an out-of-network doctor, and then they would bill these patients at out-of-network rates, right? And so this resulted, as you would imagine, in surprises. Patients were outraged, Congress acted, and then they passed the No Surprises Act and basically shut down the whole business model. And so when that happened, the cash flow didn't happen. And so Envision essentially was not able to profit. And then with its primary revenue strategy gone, they were drowning in debt, couldn't repay it, along with inflation, higher interest rates, and frankly, payers just looking at bills and refusing to pay. Essentially, they went out of business. And so with no viable way to repay debts, Envision went into bankruptcy in 2023. And the people who paid the price were physicians, right? They slashed physician pay. There were unrealistic patient quotas and forced doctors into grueling schedules with fewer resources. And so they essentially left doctors out in the cold, right? Who are unsecured creditors in the bankruptcy. So what can we learn from this? And by the way, this story repeated itself also with NES and American and APP, as well as other players as well. So what can we learn from Envision's collapse? Well, first, staffing firms, no matter how big, are not immune to financial failure, right? We often think big companies are safe. They're not. And second, your contract has to protect you from non-payment, abrupt terminations, and malpractice gaps if your staffing company goes under. So remember, a lot of these companies have private equity, so it's important to just pay attention, right? Envision here is not just a cautionary tale, it's a wake-up call. As independent contractors, you need to be vigilant and proactive and ready to walk if you get a whiff here that they're not up to snuff, and then they could collapse. And it's especially true for locums, because you don't have the same protections as employed physicians, right? There are no benefits, no guaranteed severance, and as we'll see, oftentimes no malpractice tail if the firm shuts down. And so if a staffing firm folds, your ability to collect unpaid wages depends entirely on your contract terms. So don't get punked. All right, what can you do, right? So before signing a contract here, even after you started, treat it like a stock portfolio. You have to do your due diligence, both before and importantly, during your employment there. So as locums, maybe you're not working as closely, you're not employed there necessarily in the same way. And so don't get caught off guard. A couple just basic common sense things you can and should be doing here. First, do a basic sort of public record searches, right? So if you look at a company that you're about to join, just do a search online and do some diligence, right? You can do what Rob did, which is finding credit agencies, finding out if they have significant debt, unpaid taxes, do they have loans, lawsuits, bankruptcies, bad news stories, and things like that, and online reviews. And if you see one or two bad stories, it's not the end of the world, but remember what Warren Buffett said about stocks and bonds, right? Like if there's anything bad going on, right? You never see just one cockroach in the kitchen. So meaning if you see like a lawsuit or some sort of like tax problem, that's probably indicative that they don't have their stuff together, and you should be cautious there. Next, look for churn. So frequent changes in management or ownership, high turnover, shifting leadership, right? That could kind of signal underlying issues in strategic direction, financial stability, or mismanagement. A lot of times you can see from the press releases, the company itself puts out what's going on, and that's something that should give you a sense of, is management a revolving door, or are they sort of committed to the company here? Delayed or unreliable payments or comp changes. If they are inconsistent or slow in making payments, that's a major red flag, right? Because it shows that they don't have their processes in place. And so it's basically a patchwork of various of kind of like making it up as they go. So you want to confirm with other providers or locum agencies if this has been an issue. Questions to ask. Here, what you're really looking for is asking them about accounts receivables, or transparency is what you're going for, right? Like you're asking for financial information, getting a sense of like how good are they at collecting money? Do they have a lot of debt? What are the plans? Is there a real strategy behind this company here? And part of it, when you do this diligence, is to get the information. The other part, frankly, is to see if they're stonewalling, right? Like if they're not responding and if they're not willing to share, or they're not willing to be specific about what's going on with the company, that's information too. And then you should be careful about that. So at the end of the day, the diligence here is not just about your paycheck, it's your career, your time, and frankly, the emotional toll that you could be protecting for. Couple ideas here for how you can the various contract provisions you should be looking for, right? So your contract is the first line of defense, right? And without clear protection, you could leave yourself exposed on late payments, unpaid wages, or financial instability. And so just moving atop here, couple things you may want to think about hardwiring or writing into your contract when you consider joining somebody. The first one is payment terms and schedule, right? When you have a contract, there's typically there's a pay cycle, and so you want to make sure that the pay cycle here is appropriately short. So I typically suggest for my clients like 15 to 30 days, right? Where they actually have to pay. When I read some of these news stories about providers going out of business, some doctors have been working for months without pay and they haven't paid. And part of my question is, what were they doing working for so many months without getting paid and still going at it? Part of it is, of course, the company taking advantage of your natural inclination to care about patients. You don't want to leave them in the lurch and walk away. But part of it also is, you should really think about making sure this pay cycle is very short. So if they're falling behind, you immediately know something's up. Making sure that you go with the direct deposit as opposed to just them mailing you a check, right? That can bounce or something like that may also make sense. And then you can add a late fee, right? Hardwiring a late fee or interest in it. So if they're late, they owe you a penalty, right? Part of it is also making sure if they fight very hard on this provision right here, then you know something's up too, right? Like if they are good for it, if you will, why would they fight so hard? So a lot of times the negotiation process itself will unearth sort of the position that they're in, or how comfortable they are with their finances. Termination for non-payment. Oftentimes these locums contracts just talk about like when they can let you go, right? Make sure you hardwire provisions where you can let them go, right? So if they're not paying you within 10 to 14 days, make sure you're able to exit. And then you're not going to provide any further services at all. So like just take a very hard line to it. The only reason for you to work in a locums is oftentimes for higher wages in exchange for not shorter term engagements. And so you want to make sure that you get paid here. And then also what I like to do is to link the termination for non-payment with voiding the restricted covenants, right? It doesn't make sense. They don't pay you, and then you walk away, but then they come back and say, well, hold on a second, now you can't work within our area for 2 years, a year, whatever it is. Like your response to that should be, excuse me, if you didn't pay me, I'm walking right across the street and working for somebody else. Escrow or advance payment. So for short-term engagement, sometimes you can get an upfront payment, right? Or you can request an escrow that's triggered on a late payment, meaning it's kind of like this. Like if you have a credit card and you don't pay them, the credit limit goes down right away, right? So, or if you're a tenant, you don't pay your rent or you pay it late, right? Maybe they make sure your rent is due, they accelerate your rent. And so you want to have similar provisions here to flush out those problems as they come. Legal fees for collection, right? So if you are in a position where you actually have to sue them, make sure they pay the collection costs, right? You'll hire a lawyer, maybe you take them to court, even small claims court, or you hire a lawyer to get the fees back, shift the fees over to their side, and that'll give them some pause before they decide to stiff you as opposed to somebody else. Sometimes, depending on state law, you can have a lien, like a mechanic's lien, right? Like this is common, for example, if you renovate a house and you don't pay your contractor, the contractor puts a lien on your house. So there's provisions you can potentially put in place where you can put a lien on, or you can bill the insurer directly. And then finally, transparency, right? Information and audit rights. So they have to basically provide you with financial statements to make sure that where you can monitor their solvency. I want to emphasize that none of these are a silver bullet. In other words, if the company goes belly up, they're not going to have money to pay for legal fees, right? But it's all of this is about, though, protecting. There's no silver bullet, but kind of having a number of provisions here that will set you apart from other contractors or other vendors or other physicians, where when they go through all their bills and decide who to pay or who not to pay, that they prioritize you because the penalties for not paying you is higher. So it's all about tilting that in your favor a little bit. If they push back very hard on all these provisions, that's information too, right? It means that likely that they are worried about their own solvency, and that's why they don't want to engage. Tail coverage. So tail coverage here is not just a box to check, right? It's a financial and professional safety net, and that's especially true for ER doctors, right? Because unlike derm, for example, right? For ER doctors, it's a much higher stakes. Things can go wrong because of the high stakes and high pressure environment we're in, and so you don't want to be vulnerable to lawsuits years later. And as you saw from some of these stories, doctors for these agencies that are not performing or going belly up or in bankruptcy, they are now left holding the bag. So what you want to do basically here is confirm coverage at the start. You want to require the provider to name you as an additional insured, to provide a certificate of insurance right before you begin work. So if they don't give you the proof, you're not going to work. You can hard code the tail here, right? So have an explicit requirement for the provider to buy the tail. And typically I try to make sure folks get 3 years or the statute of limitations. You can provide an option to buy it, right, where you buy it and then they reimburse you, and then make sure you have a strong indemnification clause here, right? So again, it's about having provisions that where you will end up getting the coverage. You can check on AAEM best if the insurance that they give to you is actually from a reputable company, that they're A-rated and not some fly-by-night. You want to check the coverage levels and insert the right in your contract to stop services if there's no proof of insurance. Again, this is very important for you. And increasingly what I've seen is like bring your own policy, right? Like consider your own claims made coverage with tail coverage. And then if you switch contract, especially if you switch contracts around, and then you can negotiate for them to reimburse you. And a lot of times that's more important because then you control what kind of policy you have, right? As opposed to them saying, oh, we'll provide some service, some insurance, and then they throw in a line in your contract that says, oh, and by the way, we can change the insurance coverage without notice to you.
Alex, can I break in on a moment? Because I think you bring up a really good alternative that's not quite popular yet, but I think may become increasingly popular, and that's the bring your own policy.
Yeah.
I've actually looked into this in Texas, and through the TMLT, which is probably the strongest insurer in the state of Texas, I can get an occurrence policy for less than 120 hours. So as long as it's a part-time policy, I can get that for around $10 to $15 per hour. And since that's an occurrence policy, there's no tail required on that.
Yeah.
And so I've actually talked to a few places that were willing to pay me a higher pay rate. And then I would come in with my own insurance. Now, in my current employer, I don't do that because I really trust the place that I'm at. It's a great place. But if I'm working at a place where I'm a little bit, if I know I'm coming into a distress system and I have my own policy where I am the named insured, and I want to focus on that word named insured. I control who settles and whether or not we go to court. A lot of these companies are going to use slot policies, and I will not be the named insured in that case. And if it is a slot policy, it is possible, and Alex, you can correct me because I'm, not the attorney here. It's possible that the hospital could decide to settle, or the client could decide to settle, or the locums company who owns the policy could decide against my will to settle. And then I have a mark on my record on my, on my liability moving forward. And so, like, if you're doing locums full time, it may be in your best interest to consider this because I one more caveat to that. If I'm working at a place that I know that they're not quite hitting standard of care, and that's becoming increasingly common. They're understaffing at places. They're wanting us to see 3.4 patients per hour. And I know that there's a hint of irresponsibility to the company. I may want to blame their practices as a defense. And if I'm using their insurance, is their attorney going to let me do that? I'll let you take it from there.
Yeah, no, all great points. I do see the bring your own policy becoming more popular and also really helpful, right? To your point, Rob, like if you're locums consistently, it's all about control here, right? Like who controls the policy and what are you actually getting for the policy? There's a lot of like weasel, what I call like weasel language in some of these contracts where they say, hey, yeah, sure, we'll provide you um, insurance. The provider is responsible for figuring out if it's adequate. And also we reserve the right to modify or change the insurance whenever we want. And so you kind of have some language in there, but like it doesn't mean anything because you don't control if they're going to stop the policy, if they're going to reduce the aggregate limit, et cetera. And you don't know who else is covered under the insurance because all these insurance policies, as you know, have an aggregate limit. So if there's been like a ton of claims already, and then now you get sued, there's not very much room left for your policy to be covered. And so you bring up a good point here, Rob. I think a lot of times, rather than messing around with them and negotiating back and forth, and can you do a policy that looks this way versus that way, just bring your own policy and then you negotiate a higher pay rate for yourself to offset the cost of that insurance on your own. So that they might be much more willing to do that than to like tailor make a policy in your own locums contract.
Yeah. And I think if you're only working 6 shifts a month locums, it's probably not going to be cost effective. But I mean, if you're working 10, 12 shifts, I think it's worth looking into. You actually brought up a point that I hadn't considered before. The aggregates on that policy may be for the whole group, not just the individual physician.
Yeah. Yeah.
Wow.
So I think so a lot of insurance companies say, okay, there's a limit of say 1 million for per incident and 3 million in the aggregate, right? But without actually diving into exactly what that means, right? You just don't know who's covered and so on and so forth. So again, you want to get clarity there and transparency there. Um, and happy to talk about that with folks as well.
Sure.
The bottom line, though, is like you want to protect yourself, right? And the point of a tail insurance is that it goes with you. And so just with various insurance products out there, right, oftentimes people just kind of gloss over what that actually covers. And for emergency physicians, that's just a mistake you can't afford to forego that coverage. So you'll see here at the bottom, NES Health, when they went under, they emailed a bunch of physicians here. This was a couple of months ago. NES does not have any funding or available cash. Consequently, NES will not be able to provide malpractice tail coverage. We've made the difficult decision to wind down and cease doing business and deeply regret the situation. Well, that's cold comfort for physicians who've spent their time and energy helping patients in the critical moments and now totally exposed to um, malpractice lawsuits years down the line. And so again, you want to make sure when you negotiate this piece up front to hard code or hardwire some of these provisions in to make sure you protect yourself. Let me spend a little bit of time talking about other common pitfalls in locums contracts as well. One of them that you're quite familiar with is the non-compete and restrictive covenants that you often see. And I see providers all the time overreaching on this, right? Again, locums contracts are time limited. They tend to be more short term. You're not working there full time, et cetera. Yet the non-restrictive covenant that I often see are just as onerous. There are three levers to a non-compete covenant, right? It's time, geography, and scope, like what kind of work you're going to be doing. And so because locums, when you're locums, you are obviously oftentimes working multiple engagements at a time. So this is something you want to pay a lot of attention to. And often I get questions about this way too late after people have already signed. And so you want to spend your energy at the front end whittling it down as much as possible, right? And that's especially important in private equity sort of owned agencies, because a lot of times a restrictive covenant will say, well, you're not going to be working within, call it 3-5 miles of any facility that the corporation owns, right? But then when there's a merger or an acquisition, all of a sudden the footprint of the company you're contracting with doubles or triples or becomes much bigger. And so you want to protect yourself against that. Physicians also often assume that these non-competes will be unenforceable, right? Recently, the Federal Trade Commission said they would do away with non-competes, but all that's tied up in litigation. It's in limbo, right? So is it on? Are they still valid? Are they not? In a way, it doesn't matter, because the mere threat of litigation can literally choke your career and cut out opportunities, because you'll end up working a new job and looking over your shoulder, or an entity will be worried about taking you on with a broad restrictive covenant because they're worried about getting sued themselves if you work with them. So make sure you find a good balance and find creative compromises, right, to these non-competes. So for example, if you start a engagement, they terminate you within 6 months or a year, that non-compete shouldn't last the full year or 2 years or whatever it is you guys agree on, right? So you want to make it coextensive, or if they fire you or terminate you without cause, right? You should be able to trim this down a fair bit here. So again, it's something to pay a lot of attention to.
Alex, so when a lot of us are working with locums companies, it's pretty common practice for a locums company to say they represent you for one of your major CMGs. So if, let's say I let Sycamore, which is a locums company I do a lot of work with, present me to US Acute Care Solutions, it is typically standard for them to claim the right to present me to US Acute Care Solutions across the country. And I've started a new conversation with recruiters, and I try to whittle that down to, hey, you represent me for US Acute Care Solutions in San Antonio.
Mm-hmm.
You don't represent me for US Acute Care Solutions in Florida and on the East Coast, blah blah blah, because it's very possible that they will be the preferred locums agency for time XYZ. But then when that time changes and somebody more competitive comes in, a new opportunity might come up, and that locums company really shouldn't have a claim to ownership if they didn't help you find the job. And so that's something that I talk to them about saying, hey, if I'm working with you at this place, your non-compete is going to be restricted to that geographic area. so that you can't represent me or you can't claim representation outside of that geographic area.
Yeah, and you're exactly right. I mean, you're right to be vigilant about that, right? Again, the whole idea is to preserve as much flexibility for yourself as you can. The other area I see is like, you can't compete within, 3 miles of wherever we operate. That is way too broad. It should be restricted to the primary site that you are assigned to, et cetera. And so, again, I think courts look at this as a balance between what's the business interest they're trying to protect and what's the impact it has on your ability to make a living. And so just to the extent when you negotiate, you just want to be able to articulate that, right? Locums, for example, are, they're not full-time employees. Maybe their interactions with patients tends to be a little bit more transient or transient. And so the interest in the company locking you up or blocking you from just working there just a lot smaller. And so you want to be able to, number one, articulate it, number two, watch out for it, and number three, cut down the non-compete as much as possible. It's always better at the front end when you come back with a red line or a revision to cut it aggressively so you end up somewhere in the middle than just somehow negotiating against yourself and be worried that they won't they'll say no. I mean, if they say no, so what, right? So you want to be aggressive, more on the aggressive end coming in. Okay, so look, your time's valuable, so last minute changes, unclear commitments, or reimbursement delays are things you should guard against, right? So I just want to make sure here that a lot of locums also travel, right? So when they cancel shifts, make sure the cancellation policy protects you, right? So make sure they give you enough advance notice. We're not talking here about just working there or not being able to work there. You want to be able to force them to give you enough advance notice because there's an opportunity cost to basically find other shifts if they're not willing to take you on. Last minute cancellations, right? You make sure that you get pay half, full, whatever it is you decide on. And then if they cancel on arrival, then they need to pay fully plus T&E or whatever you have decided. Again, the whole point here is that there's opportunity cost, or you're giving up other opportunities in order to work for them. So when they cancel, they need to pay up. In your contract, also make sure there's like you get a good sense of like what the maximum and minimum commitments are going to be, right? If there's a maximum commitment, you want to make sure you have it there because you want to be able to balance it with other locums engagements or other work that you have going on. You want to have a minimum, so you make sure that you're not going to this whole long contract and then you work like a shift every 6 months. And then confirm if you are supposed to cover call or frankly administrative work or other things. And then make sure that you're adequately compensated for that, or your regular patient contact hour rate somehow, that makes it all makes sense. A lot of times I see these contracts, the hourly rate looks fine, but then you end up getting paid only for patient contact hours, and then they load it up with all kinds of admin or committee or other kind of work that really shouldn't be there. So just value yourself and value your hours. Travel and housing reimbursement. So here, clarity is key, right? Maybe you can get a look at their T&E policy to make sure that it matches what you're used to, and then that there's a per diem is clearly defined. So just make sure you review the policies in advance, and then find out if you get advances for these kinds of expenses or reimbursement. Again, if it's in the reimbursement world, make sure there are strict deadlines and that there are document requirements, so you make sure that they don't fall behind on the bills. So when they go belly up or when they go under, that you're left sort of holding the bag here. Again, all this is about clarity, and none of this is rocket science, but make sure you kind of pay attention to this when you.
Yeah, I've been seeing recently, locums companies will start offering quote all-in rates, and you'll negotiate something that's $20 an hour higher, but they expect you to pay the travel and the housing. And I get a little nervous about that because with air travel, there's so much volatility in it now that you may be setting yourself up for failure, and you may be taking a hit. Because if you, let's say you forget to schedule your travel, it starts getting last minute, and you realize, oh no, I have to buy it now, or you buy it on a bad day, you could be losing money. So be careful with the all-in rates.
Yeah, that's a great point. And with air travel now, the way it is, right? Like even changing, then you're between a rock and a hard place. Either you eat the fee for changing like a flight or something like that, or you miss, right? Like or you're late or whatever, or you miss a shift. So yes, please pay a lot of attention there. That's a good point. Termination. So there are two kinds of termination an agreement will spell out. The first one is for cause, right? That means there's the real reason for letting you go. You lose your medical license or you're convicted, and often it's immediate. The second is not for cause termination, where it's like really not your fault. They don't have enough hours. They can't keep you on. It's for convenience. And this is more of a general point, but too many contracts give the agency or the firm way too much discretion, right? Total free rein in its absolute discretion. They can do whatever they want, right, in terminating you. And here you can look to even the playing field in a few ways. So, for example, you can make it mutual. What we talked about earlier, if they're late in paying, you can terminate them or they're debarred. Um, you can narrow the reasons for which you can be terminated, right? There's a big difference between termination on being investigated for something versus termination on being convicted of something. So we want to make sure that it's appropriately scoped and you can reduce the subjectivity. Again, a lot of times these companies say, in our sole opinion, if we feel you have done something to harm our interests, we can let you go. No, don't go for that. Make sure it's like a good faith determination for material sort of violations, or if you knowingly did something, then it's ground for termination. Again, you don't want to make it too easy for them to just let you go. For a lot of these provisions, also make sure you have a notice and cure period. So if you did something, they can't just tear up the agreement. They have to tell you, hey, you need to fix this, and then give you an opportunity to fix it. Again, just basically common sense. And then on without cause termination, maybe you want to include a long advance notice period. It's hard enough, right, to get a arrangement or sign up with somebody that you feel comfortable with. So make sure they give you a long enough advance notice so at least you can find time to find another arrangement. Other common contract issues, I'll breeze through, just watching the time here. So, contract issues that often come up is outside activities and moonlighting, right? A lot of times they say you can't, or they severely restrict, or we have to agree, right? If you're going to take on other activities. Well, if you're locums, you're working, it should be assumed that you're working with other people. And so make sure that you don't have to get their consent as long as it's not competitive, or they have to give consent but it can't be unreasonably withheld. That's a magic language I often put in these contracts to make sure you get max flexibility. Start dates, right? Make sure that credentialing can take a long time. So if they give you a specific start date and you can't make it, they can't just terminate you, right? Notifications. So if you're sued or something like that, right? Make sure the scope of what you have to let them know is okay with you. Access to medical records, right? Again, if you're gonna defend a lawsuit, that you still have access to records, and that's reasonable. This is what you talked about earlier. If you're sued and they settle, make sure you get a say in the settlement, right? Because you don't want them throwing you under the bus and be like, oh yeah, so and so doc locum doc emergency physicians totally messed it up, totally screwed it up, and it's somehow now in court papers or a settlement, and then you may get reported or people look you up, and then so make sure you have a say. And then if there are bonuses or incentives, make sure that they are objectively defined as opposed to subjectively defined, so there's no disputes here. So again, it's all sort of common sense, but important to have.
I'd actually caution doctors on working locums assignments where there is a RVU component to it. You have such a short-term relationship with a company that, one, you're never going to verify your RVUs. They're never going to provide you with your billing. and you're just going to be at their word. And if they start hitting financial difficulties, is it going to be in their interest to make sure you get your RVU payments, or is it in their best interest to try to salvage the physicians that are full-time there? And so I personally will never take anything but hourly work in locums jobs.
Yeah. Okay, so far we focused on key terms, etc., but it's like the what of negotiations. And let me talk about the how, and I'll just keep it short here. But basically, what I want to impress on everybody here, to the extent you're not already doing it, is you have to be your number one client. A lot of doctors and emergency physicians, they're so patient focused. They are absolute tigers when it comes to like defending or advocating or fighting for the patients. But when it comes to fighting for themselves, they turn into absolute lambs. And so it just kills me to see sometimes people just saying, oh, it's okay, I'll just sign the contract. It's like, no, don't sign the contract. Like you have to fight, right? And the approach here is, kind of being friendly aggressive, right? If you think about a 2x2 grid where, you can either be friendly or unfriendly, or you can be wimpy or aggressive in terms of your negotiation style. You want to be like friendly and aggressive, like assertive, but sort of like very calm. It doesn't have to be nasty. You just want to make sure you secure yourself a good deal. And so the mindset here, what I said about early, just deciding of I'm just not gonna just take whatever they put in front of me, the PDF that they sent me pre-signed. I'm going to actually mark it up and push back a little bit here to see what can be done will go a long way. Oftentimes inserting just one word will make a big difference. So a material, is it a violation, like a tiny, tiny violation, or is it a material violation that results in termination? Or do you have to do something knowingly versus just doing something, right? So make sure you're able to insert those provisions to really be able to fight. And finally, don't bring a medical degree to a legal fight. A lot of these contracts were written by lawyers, reviewed by lawyers, vetted by lawyers. And so, just don't wing it. Make sure um, you work with somebody who can potentially protect you, and make sure that you don't, in the heat of the moment, just um, end up sort of exposed. A little bit about me. I was a pre-med in college, and after organic chemistry, decided that advocacy, not the stethoscope, is my weapon of choice. I graduated from Harvard and Yale Law, have 20 years of experience and specialize in physician contracts. And really, what I'm doing here is a labor of love, right? After years of seeing doctor friends and family treated like widgets, I decided to start this and would love to work to make you. I mean, the way the field has moved here, and you may relate to this, is a lot of contracts are so disrespectful of doctors, emergency physicians now, right? So yesterday I just edited an agreement where the provider wanted $100,000 in liquidated damages if you cannot start by the start date. And so it's just a non-starter, but you start seeing this more and more. And so I'm really honored to be invited here and talk to you about this. The photo you see, by the way, is me finishing a marathon, where I'm tired and happy, and I assume this is what you all feel on your best days in the emergency room, and that's what I hope to be able to do. So thank you very much for your time, and we have about 10 minutes or so for questions, and happy to take them.
Yeah, this has been awesome. I really appreciate this. And honestly, in the Q&A is sometimes where we get into the best meat, so I don't want to delay too much. We did have a question that I am going to use as a springboard to show um, an exhibit here. So one of the attendees asked, you say to insure the tail. Contracts often say tail coverage is included. How does this protect you if they go bankrupt? Also, do they pay for tail upfront as a one-time payment, or are they supposed to? Or can we ask for proof that tail is paid for? So if I can screen share for just a second, I would love to put something forward. Let's see if I can screen share. Share. screen.
Yeah, let me stop sharing.
I don't think it's you. I think it's me. All right. So what we have on the screen, can y'all see the one that says AON on it?
Yeah.
Okay.
I yeah.
So this is from an insurance company to a locums company that I blacked out. And the reason I blacked it out is we just don't want to badmouth anybody in particular. And this was sent to me by a doctor who had secured shifts with this locums company. And the recruiter had told them that tail is covered. And then they backed that, the locums company backed that by sending them this letter of coverage. And as I read through it, it says blank locums company has secured coverage with this place. The policy is written on a claims made form. It provides a 1-3 policy. The policy includes a retroactive date and reviewed and when renewed annually each year, provides prior acts coverage for all previous assignments. Providers do not need to purchase tail at the time of assignment conclusion. This Ironshore specialty policy will continue to provide coverage for past assignments retroactive to the first date of the assignment, even if a claim is made subsequent to the assignment's termination. Blah, 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 blah. Coverage is continuous until blank locums company makes a business decision to cease the coverage, at which time they would have the option to purchase tail coverage. All coverage is subject to the terms and conditions of the policy, which are typical of those found throughout the healthcare staffing industry. So can you kind of go through what this means? And is there a guarantee of tail if somebody receives a letter like this?
Yeah, so the first thing I would say is, there's so many insurance products out there that, oftentimes what happens is you get a letter like this and then you just look at it for the magic words and you sort of say to yourself, that's fine. I mean, there's a couple of sort of, I would say, red flags or weaselly language in here, right? So for example, when it says the policy in the first paragraph, the policy includes a retroactive date of May 20th and when renewed annually, right? It should say if renewed annually because down there they say, look, if the company makes a business decision to cease it's continuous until they make a business decision to cease coverage. So they're already foreshadowing that this may not go on forever. So the only way in which you get this coverage is, the company needs to maintain the policy, and that again, you don't have any control over. The other part of it is, oftentimes a policy like this is tied to the main policy, and so it may not go with you when you leave, right? So if you take multiple assignments with the same company, then yeah, you're covered by the tail, but query if you actually leave, if that tail actually follows you, or if at that time you have to buy your own policy. So in other words, it's sort of ambiguous, right? If the tail actually is guaranteed or it does actually follow you. And then of course you have to look at the contract too, your own contract. And a lot of times these contracts also include language that basically scream caveat emptor. Hey, you emergency physician are required to figure out if this is adequate. And by the way, we can change the policy at any time with or without notice, et cetera, et cetera. So again, this is kind of highlights the importance of seriously considering the bring your own policy.
Yep. Is there any language that you can put in there or is there any specific language to look for that obligates them to put tail in there? And are you just a regular, I guess, an unsecured creditor, and your complaint would just be in line with all the other unsecured creditors? How is there anything you can do to bolster your strength in asking them to guarantee tail?
Yeah, so there are a couple, like I said earlier, right? Like the easiest way to do it, frankly, is just to get a higher rate of pay so you can offset the cost of your own bring your own policy. That's probably the simplest way. The other thing to do is to add in language that like explicit language that you will provide coverage. But the problem though is that when the company goes under, right, you are not just in line with other people, other creditors, you are at the back of the line because your fees and your billings are you are an unsecured creditor. So the number one, the first in line are like bank loans that where they have collateral or the company collateralized the loans. Two are employees that have under certain circumstances greater rights, wage rights, etc., where people can, directors and officers of the company going bankrupt can actually get into massive amounts of trouble if they essentially short their employees, and then everybody else is at the end of the line. So that's even more reason to make sure you get this piece right, or at least negotiate a higher rate so you can pay for
Yeah,
your policy.
you're hitting it, and you're actually answering the next question that I saw. And I don't know who this poster is, but first of all, he opens up with, "I was a victim of NES, and I'm so sorry. I wish I wish there were more people coming to bat for you. I think this is a wonderful example of an opportunity um, for our professional organizations to sound the alarms and use very specific verbiage saying that this is unacceptable. So I stand with you, and I'm sorry you went through this." It goes on to ask the question of what language could have prevented this exposure. "I ended up purchasing an expensive tail policy." I think you covered that. Do you have anything to add to that?
Yeah, I mean, I think you can add in an explicit requirement for them to buy. Maybe you can you can say, hey, if you're in the zone of insolvency, you have to put money into escrow, right? Or you have to buy it the moment you are start to be a going concern, etc. Right? So there's some language that you can say, like at the first moment where you're falling behind on your bills, or you don't have enough money to pay bills as they become due for the next year, which means you are no longer considered a going concern. You then have to immediately buy the insurance. So you can add certain provisions where before going bankrupt, right, you're kind of seeing how you're heading towards bankruptcy. It's at that point where you are triggered and you have to pay the insurance. But again, oftentimes it's a matter of not being able to monitor it, or they're competing, when the company's in financial trouble, they're competing sort of interests or competing creditors fighting. And so it just, who's going to get the crumbs, right? So, um,
It, it's so frustrating. It feels like we're becoming smaller and smaller cogs in this wheel. And I have the feeling that if I were to come to a major company and tell them that they are going to have to put money in escrow if they become insolvent, they're going to laugh me out the door. But
they'll shake their heads, right? I think
yeah,
so. I
it's so
guess the
frustrating.
answer is there's language you can put in or language you can push for. I think a company will likely not go for a provision like that, right? So again, I think just pushing for a higher rate might
Yeah.
be the simplest way to go.
I think if you're full-time locums, I can't remember what the exact annual cost of a TMLT. I think it was um a 1-3 policy occurrence, and this is going off memory, so it's subject to error. I think it was somewhere around 14 or $15,000 a year, which if you amortize it out over the entire year, it comes out to about $10 to $15 an hour, depending on how close to that 120 hours that you're working. It just kind of removes a lot of the ambiguity in an industry that's becoming increasingly volatile against our will. And so it's just taking the autonomy and put it on your own shoulders. I got another question from an anonymous attendee. Best resource to find quotes for private coverage. I have an answer, and if you have an answer, you're welcome to share it.
No, go ahead.
So I find that state medical associations are a good start. For example, the TMA, the Texas Medical Association, works intimately with TMLT. In fact, you have to be a member of TMA in order to have TMLT coverage. And so if you go to your state medical agency and ask who the preferred insurers are, um, I think you'll probably get a good list. I know that's true in Texas, and I know that's true in Colorado because Colorado has COPIC. Pretty much if you work in Colorado, COPIC's your insurer, and it's a great insurer. And so Start talking to your state medical boards. Other than that, you can just go online or chat GPT or Perplexity and ask about these things. And the questions you want to ask is, what's their insurer rating? And an A minus is the absolute minimum you should consider. Alex, you probably have something to say about that.
Yeah, agreed. I agreed with that totally. I think, obviously you want to vet a lot of these companies when they get in trouble, they start downgrading or they start buying cheaper and cheaper policies, and then just so they can say they have a policy, but it's not worth frankly much when push comes to shove or the rubber hits the
Sure.
road.
Yeah, I have up on the screen something that a physician brought forward. They were in a negotiation with a company, and I want to highlight the section that talks about tail coverage in here. In section 5.2, tail coverage. Upon termination of this agreement for any reason, physician agrees that company shall obtain tail or continued coverage for claims made resulting from professional medical services provided on behalf of the company by physician for a term within the discretion of the company. I think that's the most important line in that entire thing. We will provide you tail. We will provide you tail. We will provide you tail as long as we feel like providing you tail. And so if you were to see this in the contract, I think a very important question would be, is there any guarantee that your tail will take you out to the statute of limitations for your given state? Because if it's just a 2-year tail, and your statute of limitations has a pediatric clause that the patient can go out to age 18 and still have a 2-year discovery, you're left uncovered for a long time, and you might be retired for several years before that lawsuit comes forward. So
Yeah,
clarifying little throwaway terms like that, I think, is very important.
totally. And if you read it closely, right, like if you're cynical about it, right, this term here is worth zero because like for a term within the discretion of the company, what is the term? That discretion could mean I want a term of like 0 days and 0 months. So it's really an out for the company here. Typically, what I try to do is to force them to specify a number of years or the statute of limitations, right? Whichever is long or something like that. So it's all about getting specificity and locking them into this language and not giving them that unfettered discretion that they wanna basically write into the contract just so they can like get out.
Yeah. And in fact, the physician pressed them on it, and the response that they gave was, we provide 30 days we provide an automatic extension of 30 days after which a premium can be purchased by the physician. I think that was the language. I can't remember exactly, but to me that sounds like there was actually no guarantee of provision of tail, and that's a really scary situation
Yeah, it's
because I think some.
disappointing. It's disappointing for me to see this, right? Like again, just from a personal perspective and kind of like why I'm doing what I'm doing is just it's like so insulting. It's like absolutely disrespectful for them to just hide behind this language and then just be like, oh well, some of the terms that you wouldn't believe, some of the terms I often see in these contracts that are being sent over with like a no red face at all. So
Yeah.
that's what
Oh,
I
and
would.
then the favorite verbiage is, this is a very standard contract. Is there any such thing as a standard contract?
Yeah, no. It's standard in the sense that they say it's standard, right? It's a way to discourage pushback or edits. Oh, it's our form contract, it's our standard contract. Here it is in PDF pre-signed, and all you got to do is sign it. So then in your minds, you're thinking, oh, gee, I guess everybody else is getting the same contract. I guess there's no room to negotiate. There's always room to negotiate.
So another questions came to me. I think it sounds like you had a good experience with Sycamore. Do you have to negotiate any other provisions other than the issue with the CMGs? Sycamore is a company that I like to recommend for a couple of reasons. One, because it's owned by Hamad Husseini, who is an emergency physician. And two, they have a policy of being transparent. If you ask them what their margins are, they will share their margins. And I'm going to not disclose their business secrets here, but honestly, to me, a margin really isn't a business secret in locums. It's a standard question that I ask all locums companies. And I can get into that on another webinar. If somebody has more questions, I can get into that. But the first question I ask of every locums company is, what is your margin on this? What is the bill rate? What is the pay rate? So an important thing with Sycamore, when they work with some of these CMGs, and I won't say the names, but I can tell you exactly which companies. Those companies pay in arrears 90 days. So Sycamore then has to go out and take out a loan to front payroll. And so that's very important, because if you were working with Envision and they're paying you in arrears for 90 days, it's going to be 3 months before Sycamore doesn't get their check. And by that time, you have worked a lot of shifts. And so one thing I really like about Sycamore is they pay within, I think, about 2 weeks. So they're not perfect. I have my beef with every locums companies I've ever worked with. And personally, I'd rather not even work with a locums company, because hey, that's just leaving money on the table. But of the locums companies that I have a long experience with, I really don't have much negative to say about stuff like that. The fact that they do front the payroll and take the risk on themselves is very laudable. So if there's any further questions on that, you can always ask them. What are other issues with some of the CMGs with Sycamore? That's kind of one of the big ones. Here's an interesting part of their margin. Some of the locums companies actually charge, pardon me, some of the CMGs actually charge the locums company a fee to work with them. For example, Team Health, I believe, has somewhere around 3% or 3.5% that they add on to the bill rate, which the locums companies have to pay for, I guess, back office at some of these places. So that's an important part of understanding the margins, but that's kind of getting away from this conversation. So no, it's a company that I like. I've had some conversations with United Locums, Ali Chaudhary. I haven't personally worked with them, but they're an office of 6 people, and they claim to have very thin margins. And Ali says he'll tell any physician the margin if they're serious about a deal. I haven't tested him on it though. And then BHP, if you're up in the northwest. That's been a company that I've had good success with. They charge a flat $30 on the bill rate, unless the insurance is being provided for them, then there's an upcharge there. But and overall, on finding locums companies, I really like physician owned. I'm not a big fan of the big boxes. Their recruiters come and they go. They may be minimally trained and they may be working multiple specialties. So I ask, who owns you? I ask, will you discuss margins? And then we have the conversation from there. So hopefully that answers that question. There is a question. I've already worked for a company per diem for 2 years. The contract says they guarantee tail. How do I ensure they will? Is there a way to ask for proof? Alex, we didn't talk about COIs, certificate of insurance. I guess we can. I always ask for my COI when I leave a company, but I don't think this necessarily ensures my tail. Do you have any answer on that?
Yeah, I mean, asking for proof is you just ask them. Right, if it's in the contract, they say the guarantee tail. Now I want to know what the tail is. Send me the policy, tell me what the limits are, and give me additional information so I can make an informed decision. If you see something that's not appropriate, or like if the coverage is short or you don't want it, you can raise that conversation with them. It's probably likely a little bit too late now to change it, but at least you'll have transparency and you know what you're in for.
Okay, that's great. Well, this conversation highlights why we can't afford to treat contracts as afterthoughts, especially in this environment where groups are folding, rates are getting squeezed, and malpractice coverage isn't always guaranteed. Alex, I really appreciate you for walking us through all these critical areas. If you guys take away one thing, it's that you have to read and negotiate your contracts like your career depends on it. If you want help reviewing your own contracts, Alex is available, and we'll make sure that you have his contact after the talk. Additionally, we're getting close to Scientific Assembly in 2020 or in Miami, and there's 3 key events I want to note for locums-minded docs. First, the AAEM Locum Tenens section is going to be presenting a talk on April 7th at 8:30, just before the opening remarks, called W-2 Employment LOL. How to be a master at Locum Tenens, own your own destiny, and avoid mistakes in the process. The second talk is in the RSA track, the resident and student track. And there's going to be a talk by Ali Chaudhary from United Locums. And it's right before the Locums section meeting on April 9th. And it's titled Locums as the Antidote for Burnout. You don't have to be a resident to attend that meeting. It is the RSA track, but anybody can go to it. And then third, and closest to my heart right now, the Locum Tenens section meeting will be April 9th at 1 p.m. This is going to be a forum for candidates interested in the position of chair-elect to speak and hold elections. Right now, we have one person running for chair-elect, and so if you are interested, this is a great time to consider getting into leadership. We also have open spots on the council, so if you're interested in participating as a council member, email me by April 1st, and we'll make sure your name gets entered. But I'm interested in hearing from you guys. What talks do you want to hear this year? What's keeping you up at night? What bothers you in locums? If you have this question, 100 other people have this question. Send it to me and we can dedicate an entire hour, maybe even a small series on the question. So I'm looking for top end locums docs that are interested in telling their story. If you think you have locums figured out, I'd love to meet with you and brainstorm. I want to hear what you're doing and get you involved with the section. So if you want to talk to me offline, my email address is Mohr, M-O-H-R, mountainmedicine@gmail.com. That's Mohr, mountainmedicine@gmail.com. M-O-H-R, mountainmedicine@gmail.com. Alex, you're the man. Thank you so much. Let me check, make sure there's no questions that I left out. Oh my gosh, there's 4 more questions. All right. Do you have time?
Yeah, let's do it.
All right. So I've handled that one. Anonymous, this was excellent. Thanks for doing this. You are welcome. And another wonderful thank you. All right. If you've already signed a contract, can you renegotiate at the 1-year mark to add in some things that you should have spoken about earlier?
Yeah, so it depends on the contract, right? Like some of the contracts have like an initial term, it's like here's a year and then it's renewable or automatically renewable, et cetera. So you can always try to renegotiate that. It's probably so it depends on what your contract says is the short answer. Even if it doesn't say here's what it is, you can try to raise it anyway, and it's a little bit more of an uphill battle because it's kind of like they already have you, like why pay for the milk if you what's that expression with the
Why
cow?
pay for the cow if you already have the milk?
It's kind of like that, but you can always raise it, right? And then I think what you can also do is you can ask for some of the information I suggest that you ask for, right, on insurance or your financial solvency. And if something's not to your liking, you can tell them, hey, look, this wasn't disclosed to me early on. Can we have some supplemental language, or can we have a contract amendment? So you can always do that as well, and give it a shot. It's better than doing nothing.
I'm more aggressive on this. Remember, if you're working locums, you're working for a distress system. They need you. Okay. The question is, what is your BATNA? What is your best alternative to a negotiated agreement? If you have 2 or 3 clients at a time, your BATNA is you just pick up shifts somewhere else. And so as a locum stock, I like having 2 clients all the time. If I come into a place, usually if they've recruited me, they're going to sign me up for 90 days worth of shifts before I work my first shift. That's just kind of how the scheduling works. Schedules come out 90 days in advance. You've already signed up for three months of work before you ever work your first shift. And so it's not uncommon for me to go into a place and realize, oh my gosh, there was a place out in El Paso that I walked into. My first day was the El Paso shooting, the shooting in the Walmart, and I was the only person there with mass cal experience, military experience, and the place was a doo-doo show. I realized on that very first day that this place could not maintain standard of care. And I went back to the company and said, hey, I'm not comfortable working here. The rate that we agreed on didn't quite meet, didn't describe how this place really worked. And I renegotiated that contract. So as a locums guy, you actually do hold some decent leverage. Yes, you're very replaceable, but they're in a distressed state. So if they're coming to you, they need you. And if they weren't forthright up front about how hard the job is, You know, that's worth something. If you're staying 2 hours late every day doing notes, there's one or two problems wrong. Either they misrepresented the site, or you're just inefficient in your work. Don't let them talk you into believing that it's just your problem. If that doctor's not coming in with a little bit of overlap and it's a busy place, they either need to be paying you for that extra time that you're staying late, or you need to renegotiate your rate to cover that. So don't be afraid to renegotiate with these companies.
Yeah,
Locums
well said.
is growing. Locums is up 8% from last year. It's grown every year. More and more doctors are walking away from the W-2 employment model because it just doesn't make sense anymore for a lot of people. And so locums is only going to get bigger. So don't be afraid to negotiate on your own behalf. Last question. Oh, it just says thank you so much. Unless anybody else has anything, I think this is where we end it. Remember, we have our upcoming section meeting. Please consider running for a council member position, or even chair-elect if you think you have the experience. Shoot me an email and we can talk about it. Thank you so much, guys.
Thanks for having me.
Cheers.